Our next case is St. Clair versus XPO Logistics. This is a 20-minute mini oral argument on the application. I believe that appellees will be splitting their time, and we'll keep track of that, 10 minutes each. You may reserve time for rebuttal. We just ask that you keep track of that yourself and let us know how long you would like. You can begin when you're ready.
All right, good afternoon, Your Honors. May it please the Court, Michael Desi, I'm appearing on behalf of the appellant. I would like to reserve 4 minutes for rebuttal, and I'll try to keep track of that on my clock here. Your Honors, we're here this morning because the Court has granted an order to hear 2 issues. The first issue deals with sort of a civil procedure question of tolling and the interplay of 2 statutes, the tolling statute of 600-5856, as well as a second statute, the relation back statute of 600.2957. I'm going to tell the Court exactly how I believe the Court should decide that first issue, and then I'll discuss the second one. I believe that the Court should adopt the analysis of Judge Shapiro in his dissent, and the Court should hold that plaintiff's claim against CMC is not barred as of the date that the federal court was deemed to have acquired jurisdiction over defendant CMC. So why do I say deemed to have acquired jurisdiction? Because by operation of 2957, even though CMC came into the federal case in August, they were deemed to have been part of the federal case since January when the case was filed. So I believe it's a very straightforward analysis and application of those 2 statutes together. Now, the Court can reach that conclusion based on the plain language of the statute, 2957, which refers to a cause of action, not a case. And I believe that by expressly using the terms cause of action in 2957, that gives this Court the authority to adopt the rule that they were deemed to have been part of the federal case as of the earlier date. That is how I believe the Court should answer the first tolling question under 600-5856 in combination with 600.2957. The second question deals with the statutory misuse defense. I believe that the Court should interpret that statute expressly and strictly under its terms as to what constitutes a misuse. And there's no disagreement in this case that the failure to use the safety clip to the treadmill was a misuse. However, before the Court reaches that question, I believe there's 2 other very important ancillary questions that the Court needs to address, which is the standard of review, which I believe the Court should adopt a de novo standard of review when reviewing questions for misuse under 2947. And I also believe, and I say that because the Court of Appeals applied a clearly erroneous standard, which I believe is incorrect. The statute tells us that these are legal issues, and legal issues are reviewed under de novo. And I also believe that the Court should make clear that where there are factual disputes underlying that question, those factual disputes are decided by the jury, which is why I've said in my brief that I believe that is a fact question. The Court of Appeals held that it was a question for the Court and that it was a question for the Court to decide the facts, and therefore it then applied a clearly erroneous standard. Again, I believe that's incorrect, and there is authority in case law that has been presented at least to this Court in the past. I'm referring in particular to the Iliad's case that presented itself to this Court. Justice Zara wrote an order remanding the Iliad's case in 2018. And the Court of Appeals, both times in the Iliad's case, made clear that they applied basically they applied the standard where the factual disputes underlying the misuse would be submitted to a jury. And I'm asking the Court to adopt that same standard in this case, finding that there was a dispute in the record evidence as to whether there was a statutory misuse. And under a de novo review, I believe that the majority decision of the Court of Appeals wrongly decided that issue. And that's how I believe the court should answer the second question under the statutory misuse, that there were factual questions precluding the statutory misuse defense as to whether it was reasonably foreseeable, and because there was record evidence disputing whether the defendant Icon knew or had reason to know that the treadmill would be used without a safety clip, then that question would be submitted to a jury. That is how I believe the court should answer both of these questions. If the court has any questions, certainly I know I've already exceeded my 2 minutes, but I'm happy to answer any questions before I go any further into my arguments. All right. I guess it's doesn't seem as interesting as a question, does it?
MCL 600.2957.2 has been referred to as a relation back provision. Is that an accurate and fair characterization of that? I know this court said that in the past, but
yeah.
If
so
it were worth a blank slate, what would you call it?
You know, I would be remiss if I did not discuss this. I've told my colleagues, I teach civil procedure. I'm an adjunct at Detroit Mercy. They keep me around for some reason. And so this case really, it's just so fitting that I'm the one that had this issue present itself to me, because I'm probably more excited than anyone else in this room about it. But to answer your question, yes, I do believe it's a relation back statute. Now, of course, the federal court also has a relation back statute. But I think the question, it's a little more easier when we try to figure out how do we apply it. We know the federal court had to apply the state substantive rules in these statutes, and we know that because that's what the basis of the Erie Doctrine is. So taking it a step further, once the case was dismissed from federal court because diversity jurisdiction had been broken by the addition of the CMC defendant, it was refiled the same day in state court. Now, there's another doctrine that a lot of people don't yet often hear about. I do teach it to my students, and they ask me why, but it's called the converse Erie Doctrine, which is when you're in state court applying federal law. It might not be on all fours with what we have, but the point of the Erie and converse Erie doctrines are that when you apply these rules, they're supposed to come out the same way. You're supposed to reach the same result in a federal forum or a state forum. Now, some of my colleagues keep saying, well, Michael, we don't really like your analogy to the Erie Doctrine in this case. But it does make sense because we're supposed to be applying these two statutes, the 2957, the relation back statute, as well as 5856. And if the federal court applied these two statutes together and diversity was broken by no fault of the plaintiffs, we must and should apply these two statutes for the same reason in the state court. And that's what the guarantee trust decision from the U.S. Supreme Court said. That was decided in 1945, a few years after Erie, which was decided in 38. There was all of this chaos about how Erie was supposed to be applied. And there were all these cases, and that went up to the Supreme Court, and the court said, well, we have to determine whether something's procedural or substantive, and we don't know how we're supposed to apply it. In this instance, the court said, this was Justice Frankfurter in 1945 in the guarantee trust case, and he said, look, it doesn't really matter whether you call something procedural or substantive. The important and dispositive inquiry is that the same set of rules should come to the same outcome in the two forums, all right? So whether it's a matter of looking at the statute on its face and looking at the express language, and again, the express language of 2957-2 says it does refer to a cause of action. So I believe the court is well within its power and authority to simply adopt that the analysis of Judge Shapiro and say, well, if the statute refers to a cause of action and a cause of action has to relate back, the same cause of action was filed in the state court after it was dismissed from the federal court. But it also coincides with the policy decisions behind the statute, which Judge Shapiro points out in his dissent, which is if the legislature saw fit to pass a statute in order to give a plaintiff an opportunity to bring an additional defendant that was unknown to the plaintiff at the time of filing, then the legislator saw fit that that same defendant would not be barred once they were brought in because it would relate back. So I know, Justice Zara, it probably was a long answer to your question, but I was probably overly excited by the idea of talking about civil procedure issues. My students will love that, by the way, because they say to me, does this matter? I say, no, it never matters because it never comes up. Never. I tell them, this never comes up. But of course, here we are. So I guess it does come up every once in a while, right?
Well, let's keep talking about civil procedure, and because I don't necessarily disagree with you about how the system should work. The struggle I'm having is how do we get there through the language of this particular statute? In other words, this might be a problem that needs a legislative fix because this statute doesn't accommodate your argument. I read the statute, you want us to I mean, your opposing counsel might say, you want us to read language into the statute to make it a relation back provision. You know, the federal statute or civil Rule of Civil Procedure 15 says an amendment of the pleading relates back to the date of the original pleading. We don't have that with respect to 2957.
Well,
Instead, it reads more like an anti-dismissal statute. So where from the language of the statute can I get to your very eminently reasonable position that we shouldn't have this gap just because your client lost diversity jurisdiction when this other defendant was brought in?
well, Your Honor, that's where I guess I disagree because I think that we can read that statute because it refers specifically to a cause of action. So I don't think we have to apply 2957 per se in the state court. We only then have to use 50.
But it says a cause of action is not barred.
Right.
It doesn't say the amendment adding a defendant relates back to the original pleading vis-a-vis that cause of action. So other than just saying it, do you have any reasons why we should be persuaded by your, in other words, I get the conclusion, I get the position you want like us to end up in. How do we get there? That word, what is that? What's inherent in the word cause of action that tells me we should deem it as relating back to the original filing date?
Well, I would look at it like this, Your Honor, and I cited some statutes in my brief where the legislature has referred to in certain statutes for venue, for instance, as a case. They've said a certain case. They didn't use case in this instance, they used cause of action. So I believe at least it's different in the sense that by referring to a cause of action, and I understand Your Honor's position, but I think one, the actual language of the statute which refers to a cause of action, and I believe that interpreting it in the way consistent with plaintiff's position is also consistent with the policy directives. And then thirdly, I think it's consistent with what we know is the landscape of the law from the Erie Doctrine and the converse Erie Doctrine and its progeny, which is we can't have a case come out two different ways simply because of the forum. And I don't think the plaintiff should be faulted for the fact that she opted to file in federal court, which was her constitutional right to file and invoke the diversity jurisdiction of the federal court. And it also wasn't her fault, nor should she be faulted by the fact that once she did learn of the additional defendant, and I know it might not seem that satisfying to you, Your Honor, but I think that...
I think I agree with you that there's an unfairness here. I'm just not sure we can remedy it. It might be the folks on the other side of the mall here.
Well, I disagree. I think the court could interpret it to say that it applies in combination with 2856. And we know 2856 has been held, it's well-established law that a case is considered told from the moment it's pending in federal court. And we know we already know that's the law. So 5856 gives us the first part of the answer, and I think that the 2957, by use of cause of action, I think that the court should, again, use the dispositive inquiry of when did the federal court, when was it deemed to have acquired jurisdiction over the defendant who was brought in by virtue of 2957. On the flip side of that, I would say to Your Honor, both the federal court and the state courts recognize a relation back doctrine. This is just a fiat in the sense that plaintiff lost federal jurisdiction because diversity was broken and then had to refile the case in state court, which she did the same day. So certainly it wasn't through any dilatory actions on the plaintiff's part that she ended up in state court. If she would have, let's look at it this way, if she would have filed this case originally in state court and the defendant would have exercised their right to remove the case if they would have filed in state court and the defendant would have removed the case to federal court and then added CMC, it would have been remanded back to state court and we wouldn't be here. So, but you don't have the option of a remand when you file initially in federal court. So you can only remand once if you come from state court to federal court and then back. So that's the only way to get the remand. I believe the court should answer the question based on the express language of 2957 in the sense that it does refer to a cause of action and that it is consistent with the policy reasons for the purpose for why the legislature passed the statute in the first place, which would not, it would be violated in this instance. Do want to turn my time to the misuse defense, since I've reserved some time for rebuttal. On the statutory misuse
Before you start,
Yeah.
because I'm glad that you're switching to that. Do we consider each factor of misuse in isolation? Do we look at them all together? Walk me through that.
Well, I think what has to happen is eventually, if there's factual disputes as to each, then I think the court could look at them in combination, except when there's a factual dispute as to the different factors. So in this instance, and I would also like to point out, I don't believe that the failure to read the owner's manual is a misuse, all right? I think that's a red herring that was raised. The misuse, as Judge Shapiro notes, it's directed at how you use a product. And I don't think that saying, well, you didn't read the owner's manual could constitute a misuse in the first instance. But if there are multiple factors and there is a dispute as to whether those factors should have been reasonably foreseeable to the defendant, then I think that those would have to be submitted. Those would be factual disputes that would have to be submitted to a jury. So I do think because the statute says that it's a legal issue, I think the court can look at them in totem. But where there are disputes as to each factor, then I think ultimately the court would have to parse it out and say, well, we're going to grant summary disposition or find that this particular misuse perhaps was not reasonably foreseeable, but this one was, there's a factual dispute as to whether this one was reasonably foreseeable. Now, if you found one, I guess that would be the end of your case. But in this instance, the misuse that is at issue was the failure to use a safety clip. And just as an aside, anybody can go in a gym and you can see a dozen treadmills lined up, and you will never see anybody connected to that clip, never. I don't think I've ever seen someone actually connected to that safety clip. But anecdotally, for what that's worth, the question of whether they knew that was reasonably foreseeable, I mean, they're advertising that product with a photograph of a woman running, not walking, but running without using the safety clip. So it's my position that there was at least enough record evidence to create a factual dispute as to whether that misuse was reasonably foreseeable, and I would ask the court to answer that question in the affirmative, that there was enough evidence. And again...
But don't we have to layer in then the clearance distance? So was that
Well,
also foreseeable with it? Do we look at it together?
I think you could, yes, I think you should look at it together, but on the clearance and distance, I would just also note, the professional installers didn't know. So, I mean, that's certainly evidence that it was reasonably foreseeable or should be considered reasonably foreseeable to the defendant, because remember, keep in mind, the plaintiff hired professional installers to bring this out because, they wanted to put those decisions into the hands of professionals that knew better than they did, and the professional installers didn't know that. And there's record evidence from Mr. Chadwick, who testified. He was the director of XPO or CMC. I'm forgetting which one, but he testified that wasn't something he knew. So if the installers didn't know that, then it certainly goes to the same question, that there's certainly question of fact that was reasonably foreseeable to the defendant, that somebody wouldn't know where to place it. So I think that would be the answer to the question.
And then what about, and I know you responded to this somewhat in the briefing, but sort of this allegation about medications. I think you said that the evidence showed it didn't affect anything.
Yeah. I don't think the medications has anything to do with it. As Judge Shapiro pointed out in his dissent, at best, that may be a comparative negligence argument. Because again, the statute refers to as for misuse. It's directed at how you use the product, not whether you might have a foggy mind, or whether you might have taken medication that day, or whether you're wearing the wrong kind of shoe, or whether you're not wearing the right kind of exercise clothing. Those are external factors, and the medication also would be an external factor. So I don't believe that is a misuse at all. I don't think it should be considered one of the factors that the court considers at all. But. So
let's just assume the case was just about meds, where it did impact her, ability to walk clearly or, precisely. You're saying that wouldn't fall under the misuse statute?
No, I don't think so, Your Honor. I think that would just be an issue of comparative negligence. If they could go to the jury and argue all that they want, that it wasn't wise, shouldn't have done it, shouldn't have taken medications, you were on a treadmill. But I think that just goes to the comparative negligence at most, and I'm not conceding it's comparative negligence. I'm just saying it would go to the issue of comparative negligence.
Thank you.
So I see I've only left about a minute of my time for rebuttal. If anybody has any, Justice, have any questions?
Oh, thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court. Lincoln Herware on behalf of Icon Health and Fitness, Inc., the designer and the manufacturer of the ProForm Performance 300 treadmill that is at the center of this case. I'm here to discuss the misuse statutory defense and why it applies under the circumstances of this case. But I think it's vitally important that when you're considering this issue and Mr. Cadelli's issue, that you consider the context of this case, because it's been sanded a lot. I'm not blaming anyone. Wouldn't blame Mr. Desi for trying to reshape the context of this case. But plaintiff's complaint as it regards products liability, when it was filed, he included initially claims of defective design, defective manufacture, failure to warn, breach of implied warranties, and gross negligence. But in response to Icon's motion for summary disposition, plaintiff abandoned, either expressly or by simply not responding, not presenting any evidence, every claim in this case except a failure to warn. Now, plaintiff wants to overcome the misuse defense and get you to say that the misuse was reasonably foreseeable in order, and this is misuse that includes disregarding warnings that were both on board, on decals, on the treadmill, and in the user's manual. And she wants to be able to proceed with a claim for failure to warn based on the fact that the user's manual that she did not read wasn't specific enough. And I'm not here to argue Mr. Cadelli's client's point, but here's another piece of context. The defining characteristic of this particular treadmill was the fact that it was portable. This was not something, he keeps referring to installers. Yeah, I imagine there's some gym equipment that should be installed, but this was delivered. This was a portable treadmill. It was designed so that you could fold it up like an ironing board, roll it away, put it aside, put it in a closet when you're not using it, and then bring it out, set it up, and use it. In fact, two of the very detailed warning decals are on the bottom. You can't even see them if you leave the treadmill out and set up. When you go to get your treadmill and you look at it, there would be these warning labels, and you would push it out, put it down, and use it. So this idea that they were relying on professional installers not to put it up against the wall, the installers aren't going to come out there every day and set up their treadmill for them. This would be a lot like, I tripped over my vacuum cleaner because that's where the guys who delivered it left it, right in the hallway. So that's the context, but let's talk about misuse. I've been accused, if you read MAJ's, the Michigan Association of Justices amicus brief, they rely on a false, an erroneous, hopefully inadvertently mistaken statement in a brief written by Mr. Desi that says we didn't preserve this argument where we identified all of the misuses. I would tell you that the act that governs product liability cases defines misuse 4 ways. It actually has one umbrella definition, and then it gives you 3 definitions of what is included within that umbrella. Only one of those is the failure to disregard warnings and instructions of the manufacturer. Another one of those definitions, though, is uses that would not be considered suitable by a reasonably prudent person. Basically, negligence. If you're going to be negligent, and that is, obviously we're going back to the basics. What is a reasonably prudent person? What would they do? But that's defined as misuse. Now, Judge Shapiro would like to just disregard that definition of misuse. And if you're going to say that this person did something that a reasonably prudent person wouldn't do, well, you'll just use that at the comparative negligence phase of the case. But the legislature can't just be ignored. When the legislature says that negligent use of it is misuse, a reasonably prudent person wouldn't do that, that's misuse. Then you're going to have to use this twice. First, you're going to have to determine if it was misuse. Then you're going to have to determine whether the misuse was reasonably foreseeable. And if you then get to a jury, you can make your arguments for comparative negligence. But you don't just ignore it at the misuse phase of this litigation. We identified 5 different types of misuse in our October 13th, 2020 motion for summary disposition, and in our November 12th reply brief in support of summary disposition, and at oral arguments on November 16th, 2020. And I'm not going to bore you and read them. I summarized some of them here, and I thought, I'm going to show them that we preserved this. But we identified 5 of them. Potentially 4, there could really be some overlap between the idea that she didn't read the instructions in the user manual, and she was unfamiliar with how to use the treadmill. There's overlap simply because obviously the user manual is one way that she could have learned how to use the treadmill. Her defense to that at her deposition was that she was relying on her husband to teach her how to use the treadmill. And so, if she was going to rely on him, then obviously we would expect that he would have taught her how to use the treadmill, or she would have learned from him how to use the treadmill, and she failed to do that as well. I'm certain plaintiff's counsel wants to say that the only thing that we have to look at is her failure to use the lanyard. But guess what? If she had known how to use the treadmill, if she had known how to put it on the lowest speed, which was her intention, she said, well, okay, I don't need to use the lanyard because I'm only going to use it at a walking pace. But she didn't know how to use it at a walking pace. Instead of putting it on the lowest speed, what did she do? She put it on program 1. I use a treadmill every day, but I never use the programs because guess what the programs do? At some point, they just speed up. They'll increase the incline. They're giving you a workout program, and it's easy enough to just put your finger down and increase the speed if I need to increase the speed. When that program advanced the speed of the treadmill, it took her by surprise. She didn't know it was going to happen. Why didn't she know it was going to happen? She didn't learn how to use the treadmill. She didn't know, she wasn't expecting it. Those two things had to come together, the failure to use the lanyard and her unfamiliarity with how to use the treadmill in order for that fall to happen. And the fall itself isn't what caused the abradement injury. She had to not know how to use the treadmill and not wear the lanyard and have the treadmill too close to the wall in order for her abradement injury to happen. And the fact that the trial court didn't consider the medication and the Court of Appeals affirmed based on what the trial court said doesn't mean the medication isn't misused. And there's no one here that would think, is driving drunk a misuse of a motor vehicle? I think it is. I see cough medicine that says, don't operate heavy machinery while you're on this. I would imagine that morphine, Percocet, Robaxin probably on their labels say, don't operate heavy machinery while you're on these drugs. So is that misuse? Is it something that a reasonably prudent person would find to be a suitable use of the treadmill? I would argue not. Now, the idea that these are jury questions to decide misuse and decide whether misuse is reasonably foreseeable. I'm a plain language. Maybe I find it easier, but when the legislature says something, I just follow what they said. And they said it's an issue for the court to decide.
Well, the legal question of misuse and
Yes.
foreseeability is a question for the court to decide. But if there are disputed questions of fact as to whether it's foreseeable,
Okay,
And
underlying,
whether it's like that legal question, so a jury in theory could decide disputed questions of fact, and then based on that finding of the jury of the factual issues, then the court makes the legal conclusion of whether misuse and foreseeability, right?
if there were component facts, okay, so the only issue here, there was a guy named Laurel Hodges, I can't even remember our expert's name at the moment, who, he gave information, said, we haven't done a study, you know, we don't have any data on whether, you know, how many people don't use the lanyard. I know I use my lanyard every morning. Maybe at the gym they don't, but those are highly fit people, right? They're not someone in Ms. St. Clair's situation. But the only evidence here, you say you might have been aware of one of these pieces of misuse, is they found a marketing image of a very fit woman running on a treadmill. Now, I happen to know that marketing people and legal people have different ways of thinking. The lanyard apparently, you know, makes the photograph look busy or something. Judge Shapiro says when he goes to the gym, nobody's using the lanyards, but I'll bet when he goes to the gym, they don't have those treadmills 4 inches away from a wall either. And, you know, unless you're not going to have treadmills, and we say they're too dangerous, all you have to do is go on YouTube and put in like treadmill fail, and you're going to see people doing stupid things and falling down. But never in a gym are you going to see one shoved up against a wall. And never would it be a good idea to use a treadmill while you're on morphine, Percocet, and Robaxin. And always it would be a good idea to learn how to use a treadmill before you get on it and start operating it. Just like it's a good idea to know how to drive a car before you start driving one down the road. But,
I don't mean to interrupt,
Yeah.
but there's 8 minutes left.
okay.
So, just
Thank you,
wanted-
Your Honors.
yeah.
Obviously, you understand my position. Mr. Tom Cardell.
Thank you. Thomas Cardelli on behalf of CMC. I'll accept questions anytime, and I'll be brief.
Do you wear your lanyard when you're on the treadmill?
Absolutely, I'm a marathoner, so yeah.
So only plaintiff lawyers don't wear the lanyard, but the
I guess,
defense lawyers
you know,
do.
I guess. And I pull it off a lot too, you know, because I challenge myself with speed that I cannot maintain. So.
Keep up.
I'm urging the court to not accept this application. And the reason I'm urging the court not to accept this application for leave to appeal to this court is that in the nearly 30 years of tort reform, there hasn't been another case reported relative to this issue on 2957. It just hasn't happened. So this is just a very rare instance, and so this is not a case in which this court should get involved. The statute has worked. It's worked very, very well. 2957.
Why shouldn't we look at it that if this decision is allowed to stand, it will be used quite frequently, and it hasn't been come up because everybody's operating under the assumption that if you have your cause of action sort of complete and timely in federal court, whether it be because you filed it in the first instance or because, you know, you've got removal and that, and you filed your NPF and it relates back, and then you input, and then when it's dismissed, 5856 says as long as you're good and complete in federal court, then you're here. But this decision, if would say no. I mean, wouldn't that encourage people to say, look at?
No, this is a unique case for this reason. Plaintiff waited 34 months to file their original action. The non-party at fault that was filed in the federal court action was filed untimely. So in other words, XPO is the defendant at the time who filed the notice of non-party at fault under 2.112K. They filed it untimely. They had 91 days from the date that they filed their answer to file. It was untimely. They filed after their 91 days, and the plaintiff appellant here never challenged that. They could have challenged it. They should have challenged it. and therefore CMC would have never been a non-party
Well,
at fault.
couldn't have CMC have challenged their addition as a party in the filing and being subject to the amended complaint in the federal court if that were the case?
No, because by then, 2957 tells us that CMC does not get the protection of the statute of limitations because it's been identified as a non-party at fault. We cannot dispute something that occurred prior to our entering into the case. We have no standing to do that whatsoever, Your Honor. So CMC comes into the case, but the fact of the matter is, and the record is clear on this, plaintiff appellant should have challenged the filing of the notice of non-party at fault, which then triggered some almost, it was about 85 days later after that, plaintiff filed a motion for leave to file an amended complaint, and then the then existing defendants and plaintiffs stipulated to allow the amended complaint. It was never in front of the judge, Judge Stee in this case, relative to whether this was a correct notice of non-party at fault. And again, so this is a very, very unique case where by the time CMC came into this case, and we put this in the briefing too, by the time CMC came into this case, the statute had expired, by a year or so. And so any hope for them to then file another original action in another court, the statute had expired. It expired by that time. And so that's what makes this an odd and rare
Can
and
I ask
unique
just one
case.
point of clarification?
Sure,
You
yes.
You said that the MPF was filed more than 91 days after the complaint was filed, and therefore it wasn't timely. But
The answer of XPO.
I'm
See-
sorry, the answer,
Yeah.
it was more than 91 days.
Oh, yes.
But doesn't the statute allow a provision that upon learning of the identity or the potential for fault, I mean,
They-
it's 91 days if it's identified or whatever, timed within the complaint, but there is a provision, do you know which way
Yeah.
that this MPF was filed?
No, the provision in the court rule requires that if they can't file it within 91 days, if they file it after 91 days, the plaintiff can challenge that, and then the defendant has to show cause. They have to, it's the same standard as the default. They have to show cause as to why they could not have identified CMC within the 91 days. And what I'm saying is they were never challenged on that, and they would have won on that, because obviously XPO knew about CMC. We were their agent, so obviously they knew about us, and they just waited. This is just an odd case where everybody just waited to the end, and that's why, in my opinion, this is a case, and what I'm urging, this is a case that the courts should not even consider, because that's why this hasn't come up. And then again, this is a really rare, Judge Kavanaugh, if I could just expand upon that for a moment. So the plaintiff concedes with the court that he has no jurisdiction over CMC almost a year and a half after they brought CMC in. And the reason Judge Stee is looking at this case is because CMC files a motion for summary judgment. And so the judge is looking at the case and says, well, wait a second. CMC is a Michigan defendant. What are they doing here? Do I even have jurisdiction? And this is over a year after we've been in the case. And the judge orders a show cause and gives the plaintiff an opportunity to show cause. Well, what are you going to do? Should I keep the case, not keep the case? The plaintiff stipulates to dismiss the case. That's the plaintiff saying, I'll just dismiss the case.
Was CMC not aware it was a Michigan corporation when they were added to the federal suit?
Absolutely, we're aware that we're a Michigan corporation. It's not our duty to contest that jurisdiction at that stage. We don't have to do that, Your Honor. And there are instances where the federal courts do agree to keep the case. So, there could be situations where that could occur. So in any event, what plaintiff does here is he dismisses the case, And of course, as you know, we believe Judge Mastroni gets it right and says, well, wait a second, I'm looking at this statute 2957, and he states that the 2957 only relates to that federal court action, and 2957 is not in front of him as it relates to the Macomb County action, because it's a new lawsuit where CMC at this stage is a direct defendant and not brought in by an amended complaint. And so I think Judge Viviano, when you were asking questions earlier, it's a statutory issue. It's a statute. It's an issue for the legislature. If the legislature wanted to say, once 2957 is activated, it's activated for all lawsuits, they would have said that. And maybe they should say that if it's up to you. Maybe you want to go convince them to do it. But I'm just saying, for over 30 years, it's worked pretty well, just the way the legislature wrote it.
The question is, if they had thought about it, what would they do? What would a reasonable person do? Not adversaries standing opposed in the middle of a lawsuit, somebody who's trying to build a better mousetrap. Would you say if, this sort of situation happened, barring the untimeliness situation, should there still be that gap?
I don't think so, Your Honor, just based on the time, the almost 30 years, it's worked really well. I mean, you don't have any reported cases, and in fact, courts have asked plaintiffs, say, do you have any case to support you? There are no cases. I think that's an acid test, isn't it? It shows it's working.
It shows it's not a big problem or one that frequently occurs. The question is, when the infrequent times when it occurs, is it the way the system should operate? That's all. Now, maybe I still can't understand your view. Is that how, since you're asking me, I'll ask you, is that how it should work in the few times that it arises?
I think it does, because
What's the logic of it not relating back? I mean, it can't be dismissed in the federal case, but if the federal court loses jurisdiction for whatever reason and the plaintiff is then required to proceed back in state court, it just seems like that's kind of a idiosyncratic development.
But now we go back to statute of limitations, right? And the debate, and why do we have statutes of limitations? Well, we have it for a variety of reasons, right?
Well, you're a true believer, I can see.
Well, I think
I understand. I'm just just the way the statute of limitations, they're important. But we're in litigation, right? And the statute's already been dealt with. So now you're just changing from the federal forum to the state forum for unrelated reasons. So, one could argue that your client got a windfall from that fortuitous development.
Not really, because they weren't brought in originally under the 3-year
Well, what if they were and the same thing happened?
Well, see, I don't think it could, then, right? Because then it's told during the time that the case is pending. It was pending for 479 days in federal court.
No, I get it. They weren't brought in originally, but if they were third-partied in a timely way, you're saying this wouldn't arise. Is that
correct? Yeah, I think, and that goes back to my original statement. This is just a very unique situation, and one that I believe the court should look at. I think we've attached the opinion of Judge Mastroni, and as you know, that the majority of the Court of Appeals concurred with Judge Mastroni. I think both wrote well-reasoned opinions supporting the rationale that we've put forward, that this statute...
Thank you. Your time is up. I apologize. Thank you very much.
I appreciate it.
1 minute.
We have 51 seconds.
Go.
I was going to get a minute. All right, I'm going to be quick. It wouldn't have made any difference about whether the notice of non-party was filed. Mr. Cardelli says it was late or something, if it was 10 days earlier. It wouldn't have made any difference, because at the point at which they identified the non-party, it was already too late. So it doesn't matter. In other words, the statute already would have run. It doesn't matter if they filed the notice of non-party a few days late. As far as it being unique, I mean, there's a published decision now. What this is going to do is encourage parties to just simply lay in the weeds and not identify the person until after the statute runs, knowing that then you're going to lose your cause of action. Justice Kavanaugh, you raised the point about the factual issues. That's exactly what the court did in Green versus AP Products. They analogized it to the element of duty, which is a question of law, but where there are factual circumstances that give rise to the duty, the existence of those facts are decided by a jury. So that's exactly what was held in Green versus AP Products. That's my minute. That's all I have.
Thank you very much. Thank you to all of you.
Unless you have any questions.
I don't see any. Thank you. The
All right,
case will be
thank you.
submitted.